White collar crime. White collar crime. White collar crime. Please like and subscribe and comments YouTube channel Research and Criminology. Research and Criminology YouTube channel. Facebook page Research and Criminology. Facebook page Research and Criminology. Influence peddling. Influence peddling. Influence peddling and bribery. Influence peddling and bribery. The sixth component of white collar crime involves the situation in which an individual with an important institutional position sells power, influence, and information to outsiders who have an interest in influencing or predicting the activities of the institution. Offenses within this category include government employees taking kickbacks from contractors in return for awarding them contracts they could not have won on merit, or outsiders bribing government officials such as those in the Security and Exchange Commission who might sell information about future government activities. One major difference distinguishes influence peddling from the previously discussed exploitation of an institutional position. Exploitation involves forcing victims to pay for services to which they have a clear right. In contrast, influence peddlers and bribe takers use their institutional positions to grant favors and sell information to which their conspirators are not entitled. Influence peddling may not be directed solely at personal enrichment and can involve securing a favored position for one's political party or interest group. Political leaders have been convicted of securing bribes to obtain funds in order to rig state elections and allow their party to control state politics. In sum, in crimes of institutional exploitation, the victim is the person forced to pay, whereas the victim of influence peddling is the organization compromised by its own employees for their own interests. 6a. Influence peddling in government. Influence peddling in government. The most widely publicized incident of government bribery in recent years was the ABS CAM case, scam case. Here, FBI agent working with a convicted swindler, Melvin Winberg, posed as wealthy Arabs looking for favorable treatment from high-ranking politicians. The pseudo-Arabs said they wished to obtain US citizenship and receive favorable treatment in business ventures. Several office holders were indicted, including a US Senator from New Jersey, Harrison Williams. Williams was convicted of accepting an interest in an Arab-backed mining venture in return for promising to use his influence to obtain government contracts. He also promised to use his influence to help the Arab Sheikh enter and stay in the United States. At Williams' trial, the prosecution played tapes showing Williams meeting with federal undercover agents, boosting of his influence in the government, and saying he could with great pleasure talk to the President of the United States about the business venture. A later rape showed the senator promising to seek immigration help for the bogus sheikh and agreeing to take part in the mining operation. A later tape showed the senator promising to seek immigration help for the bogus sheikh and agreeing to take part in the mining operations. Even more shocking and disturbing to the US public were the 1989 revelations that officials in the Department of Housing and Urban Development channeled funds targeted for the poor into the hands of wealthy developers. Developers and consultants who were connected to the Reagan administration. One national magazine branded the conspirators as poverty pimps who got rich and powerful by subverting programs intended to help the poor. Over a period of 8 years, developers used political influence to drain billions of dollars into questionable enterprises. Even more disturbing were the former housing and urban development officials who, working as consultants and lobbyists, used their personal relationships to obtain cash for the profiteering builders. While potential influence peddlers are aware of the risk they take, they have continued to let greed dominate any sense of personal judgment or moral integrity. Just before he was arrested for bribe taking, Arizona State Representative Don Kenny asked a police informant, "You sure there is not a camera? I remember those videos of the AB scam trial." Kenny, chairman of the Arizona House Judiciary Committee, was accused of accepting $55,000 in cash for his support of legalized casino gambling. In all, nearly 10% of the members of Arizona legislature faced criminal or civil charges during 1991. Kenny is not alone. It has become all too common for legislatures and other state officials to be forced to resign or even jailed for accepting bribes in order to use their influence. In West Virginia, 2 governors have been jailed on bribery and extortion charges since 1960. In Louisiana, the state insurance commissioner was convicted in 1991 on money laundering, conspiracy and fraud charges connected to the collapse of the Champion Insurance Company, which cost policyholders $185 million. The commissioner took $2 million in bribes in return for regulatory favors. 6b. Corruption in criminal justice system. 6b. Corruption in the criminal justice system. It has also been common for agents of the criminal justice system to get caught up in official corruption. This is particularly disturbing because society expects a higher standard of moral integrity from people empowered to uphold the law and judge their fellow citizens. 6b. Corruption in the criminal justice system. It has also been common for agents of the criminal justice system to get caught up in official corruption. This is particularly disturbing because society expects a higher standard of moral integrity from people empowered to uphold the law and judge their fellow citizens. Police officers frequently have been accused of using their positions of power to coerce citizens into making payoffs. The best known instance of police corruption was brought to light when former New York Mayor John Lindsay appointed a commission under the direction of Judge Whiteman Knapp to investigate allegations of police corruption. The Knapp Commission found that police corruption was widespread, ranging from patrol officers accepting small gratuities from local business people to senior officers, gamblers, and narcotic violators. The commission found that construction firms made payoffs to have police ignore violations of city ordinances such as double parking, obstruction of sidewalks, and noise pollution. Bar owners paid police to allow them to operate after hours or to give free rein to the prostitutes, drug pushers, and gamblers operating on their premises. Drug dealers allowed police to keep money and narcotics confiscated during raids in return for their freedom. Police also gave confiscated narcotics to informers for their own use or sell to others. Gamblers made regular payoffs to keep their operations going. The payoffs to each individual amounted to $400 to $1,500 per month. The Knapp Commission report did not lay to rest police corruption. There have been noted scandals in many large cities. For example, 20 Philadelphia police officers were indicted on charges of extorting money from bar owners and video game vendors. James Martin, the former second in command of the Philadelphia Police Department, was sentenced to 18 years in prison in the case. In Chicago, police officers conspired to sell relatively new police cars to other officers to cut rate prices, forcing the department to purchase new cars unnecessarily. In Boston, a major scandal hit the police department in 1988 when a police captain was indicted in an extorting and selling scheme. Numerous officers brought promotions exams from the captain, while others had him lower the scores of rivals who were competing for the same job. A police burglary ring in Denver was so large that it promoted one commander to coin the phrase burglars in blue. Burglars in blue. During the past 20 years, police burglary rings have been uncovered in Chicago, Reno, Nashville, Cleveland, and Burlington, Vermont, among other cities. Federal prosecutors mounted Operations Grey Law to expose corruption in the Cook County, Illinois court system. The uncovered examples of judges selling favors to corrupt attorneys for up to $50,000 in under the table payments. One culprit received a 15-year prison sentence. 6C. Influence peddling in business. Influence peddling in business. Politicians and government officials are not the only ones accused of bribery. Businesses has had its share of scandals. In the 1970s, revelations were made that multinational corporations regularly made payoffs to foreign officials and business people in order to secure business contracts. Gulf oil executives admitted paying $4 million to the South Korean ruling party. Borax Corporation admitted paying $1.5 million to foreign officials. Lockheed Aircraft admitted paying $202 million. In a more recent case, McDonnell Douglas Aircraft Corporation was indicted for paying $1 million in bribes to officials of Pakistani International Airlines in order to secure orders. In response to these revelations, Congress in 1977 passed the Foreign Corrupt Practices Act (Fcpa), which makes it a criminal offense to pay bribes to foreign officials or to make other questionable overseas payments. Violation of Fcpa draws strict penalties for both the defendant company and its officers. Moreover, all fines imposed on corporate officers are paid by them and not absorbed by the company. For example, the violation of the anti-bribery provision of Fcpa, a domestic corporation can be fined up to $1 million. Moreover, company officers, employees and stockholders who are convicted of bribery may have to serve a prison sentence of up to 5 years and pay a $10,000 fine. Congressional dissatisfaction with the harshness and ambiguity of the bill has caused numerous revisions to be proposed. Despite the penalties imposed by the Fcpa, corporations that deal in foreign trade have continued to give bribes to secure favorable trade agreements. Some, such as medical supply giant Baxter International, have been accused of bribing government officials in order to obtain overseas contracts. Baxter is alleged to have bribed Arab officials in order to do business in Arab nations after it had been placed on a blacklist for owning a plant in Israel. Other companies have developed a variety of schemes to defeat the federal law. One way is to join with a foreign company that is not controlled by US law and let it negotiate the contracts. Not surprisingly, US business have complained that stiff penalties for bribery give foreign competitors the edge over domestic corporations. In European countries such as Italy and France, giving bribes to secure contracts is perfectly legal, and in West Germany, bribes are actually tax deductible. Consequently, it is possible that any future changes in the Fcpa will decriminalize some forms of bribery. 6D. Security Violations. 6D. Securities Violations.
6D. Securities Violations. 6D. Securities Violations. About form of influence peddling in business involves accepting money for information about one's employer. The information then can be used to buy and sell securities in the company, giving the trader an unfair advantage over the general public, which lacks this inside information. Another twist on the exploitation of a business position involves using deceptive practices to buy and sell shares in public traded companies. The federal securities laws that control trading in public companies can be found in a number of different statutes, but the two primary sources are the Securities Act of 1933 and the Security Exchange Act of 1934. These acts prohibit the use of manipulative or deceptive devices such as mail and wire fraud, making false statements in order to increase market share, conspiracy, and similar acts of unfair market practices. The federal watchdog agency, the Securities and Exchange Commission (SEC), has within its code Rule 10b-5, which articulates general anti-fraud provisions for security trading. It shall be unlawful for any person directly or indirectly by the use of any means or instrumentality of interstate commerce or of the mail or of any facility of any national security exchange. A. To employ any device, scheme or artifice to defraud. B. To make any untrue statement of a material fact or to omit to state a material fact necessary in order to make the statements made in light of circumstances under which they were made not misleading, or C. To engage in any act, practice or course of business which operates or would operate as a fraud or deceit upon any person in connection with the purchase or sale of any security. D. Despite efforts of the SEC to control Wall Street activities, the lure of profits in the hundreds of millions of dollars proves too enticing for some stock market traders. In the go-go 80s, they became involved in an insider trading scandal.